Hi everyone, my name is Chloe Park. I'm the LD Director of Outreach Debate Alabama, and welcome to the first LD topic lecture for the 25-26 season. This is the September-October topic, Resolved in the United States Criminal Justice System, Plea Bargaining is Just. First, on topicality debate. Topicality debate is the debate centered around the wording of the resolution. So you're not going to be talking about plea bargaining in the topicality debate. You're talking about the resolution, how it is worded, what does that imply, what does that mean. This resolution is a pretty clear one, but there might be some parts that could be ambiguous or might be up for interpretation. And in the future, there will definitely be resolutions where there are ambiguous parts that you and your opponent might disagree on. In those cases, it is absolutely imperative for you to define the key terms for your judge. Your judge, if you define a term and your opponent does not, then the judge has to look at the debate with your definitions in mind. And if your opponent is arguing something that doesn't match with your definition, then you automatically get a big advantage. So, for the plea bargaining topic, first of all, what is plea bargaining? Plea bargaining is a legal arrangement in criminal law where the defendant agrees to plead guilty or no contest to a charge in exchange for concessions from the prosecutor. That's from Wikipedia. I'm sure you can find a better definition on, the US DOJ's website. There are multiple types of plea bargains. First is charge, when you plead to a lesser charge. Second is sentence, where you get the same charge but you have a reduced sentence. And third is fact, where you agree on facts to reduce the sentence. Potential topicality debate arising from plea bargaining is, does the resolution refer to all types of plea bargaining? If it doesn't, then what types of plea bargaining does it refer to? And let's say if, for example, if charge bargaining is just, but then sentence bargaining is not just, does that mean plea bargaining as a whole is a just idea or not? Also, does this include informal deals like leniency testimony? Those are things that you might want to think about yourself before you write your case and before you think about what you're going to argue. Second part of the topicality debate is in the United States criminal justice system. Usually, United States or US generally implies the federal government. So in this case, it refers to the United States federal criminal justice system. However, some people might interpret this as state systems, which federal systems and state systems vary widely. So make sure you have a clear definition for that. Some people could also interpret this phrase to include police practices, prosecutorial discretion, correctional systems, and or public defense. So make sure you are keeping an eye on that as well. Also, make sure you're talking about the criminal justice system, so criminal cases. There are civil cases, but that is completely irrelevant to this topic. So if you have evidence or arguments based on civil cases, that is not applicable. If your opponent calls you out on that, your whole argument just doesn't apply and it's, thrown out. So make sure you are focusing on the criminal justice system. Also, the last part of the topicality, the topic that could lead to some complications is the word is. Is might seem like a meaningless word, but it's a present tense word, and it is asking currently in the status quo right now, is plea bargaining just? So make sure you keep that in mind when you are researching and thinking about how to build your case. Make sure it is relevant to the current status quo. Framework ideas. Okay, so for framework in LD, that is the most important part of an LD debate round. Framework is your perspective or point of view, it's the lens through which you see the debate round and judge it. So judges will have to pick a framework to see the debate round through. In this topic specifically, the framework for neg and af are most likely always going to be different. So if you don't agree on the framework, then you're going to have to argue for why your framework is better and why the judge should look at the debate round through your framework. So that is absolutely imperative. If you lose the framework debate, you lose the round. For example, especially in this case, if you are arguing for a utilitarianism perspective, but you lose the framework debate, the judge will have to look at it from a different perspective. For example, mitigating structural violence, then your arguments and your contentions don't match with the framework that the judge is looking through, so your case doesn't make sense. So make sure you are arguing for framework and understand the framework that you are running so that you can actually back up your points and ideas. So, going into affirmative framework, your value is most likely always going to be justice because of the word just in the resolution. Criterions you can use utilitarianism, procedural justice, retributive justice, social contract theory. There's a lot more. Especially for Alabama, utilitarianism and mitigating structural violence on the next side is the most common framework. So, I would 100% understand those two frameworks for sure. Utilitarianism is basically saying we should maximize well being and pleasure for the greatest number of people. We should prioritize the majority of the people. While mitigating structural violence, or MSV, is the complete opposite of that. It's saying we should protect minorities. So, on negative, for your value, you can honestly do anything. You can do justice, autonomy, rights, legitimacy, anything. Just make sure it fits with your case. Criterions, there's a lot of things you can do. First, you can do mitigating structural violence, MSV, which, like I said, is where you protect minorities and you stop the cycle of structural violence. You could also do deontology ethics, Rawlsian justice, due process, Kantian morality, whatever you want to do. For Rawlsian justice, Kantian morality, frameworks like that, those are philosophy based. So if you're going to run a philosophy based framework, make sure you understand what the philosopher is saying, what the philosophy believes in, what the opinions of that philosophy or philosopher are on the criminal justice system and on the issue of plea bargaining. If you have those basic ideas set, then I think you'll be good to argue for your framework. But if you don't know what Kantian morality is, then don't run Kantian morality. Okay, AF contention ideas. For AF and neg, all the contention ideas I'm sharing are what I think will be the most common contentions that you will run into. First, on AF, we have efficiency and resources. Plea bargaining resolves 90 to 95% of cases and reduces court backlog. The source I use says 90 to 95. There are other sources out there that states that plea bargaining resolves up to 98% of cases. So the vast majority of cases are resolved through plea bargaining and not actually going to trial. Plea bargaining also saves public funds and judicial time for more serious crimes and allows the justice system to focus on more serious and violent offenders. This whole court clock idea contention is used a lot in many other debates as well, even with different resolutions. So I think this is a good contention idea, even if you're not going to run it, to have a good understanding of. Second is defendant autonomy. Defendants voluntarily accept deals as a choice. Some defendants prefer certainty over the risks of a trial, and it gives defendants agency in their legal outcomes. For this contention, I would emphasize that nobody is forcing anyone to take a plea bargain. It is 100% the defendant's choice. Of course, the neg could swoop in and say, no, it's not really their choice. They could be coerced. They could feel like they have no other option to take the plea bargain, and therefore it is unjust. But you want to argue that it is a choice. They always have a choice. They can either take the plea bargain or go to trial. So it is a just, system. You would also want to emphasize the unpredictability of a jury. Once you step into a courtroom, you have a jury and you don't know what conclusion they're going to come to. So some people would prefer the certainty that plea bargaining gives rather than take the risks of going to trial and facing a jury. You could also argue for better outcomes for marginalized groups. This would directly clash with the neg contentions, especially if they are running MSV. With proper safeguards, plea bargaining can result in lighter sentences and reduce incarceration for low income and minority defendants. Going to trial often results in harsher penalties. I think this would be a good contention, especially if you are running directly against a neg case that is arguing for prioritizing minorities and helping those marginalized groups. Other ideas that you can think about is traumatization, basically saying that if we have no plea bargaining and if we go to trial, then um, people that are victims of violent crimes, maybe sexual crimes, will have to go into court, testify, share their story, and relive the trauma that they witnessed and went through. So that is overall harmful, very harmful to the victim's mental health and their personal state. And it's just not a good process for people to go through. And so we need plea bargaining for these people to, opt out and not have to go through this traumatizing court experience. Also, you could argue that plea bargaining is beneficial for everyone. It's a mutually beneficial process, with the defendant receiving a lighter sentence than they would if they went through trial. The prosecutor secures a conviction, and the judge has more time to focus on other complex cases. Okay, on the neg side, first you can argue coercion and inequality, power imbalances between the state and the defendants, especially for minorities and low income defendants, are, obvious. Prosecutors have a lot more power over the defendants, and they could potentially be coerced into taking a plea bargain. Many innocent people plead guilty to avoid harsher sentences. 20,000 plus exonerations involved guilty pleas. So I would maybe talk bringing some court cases where someone was innocent and they took a plea bargain and pled guilty because they were scared of what could happen if they went to trial. So definitely emphasizing the coercion and the power imbalance between the people involved. Second, you could talk about undermining due process and basic constitutional rights. Everyone has the right to a trial by fair jury, a speedy and fair trial by the Constitution. Plea bargaining is basically taking those constitutional rights away. You are giving them up. Plea bargaining short circuits a full defense, discovery, and evidence testing. You could argue that plea bargaining is unconstitutional. You are essentially being forced or coerced, maybe, I don't know, to give up your rights, which is something that shouldn't be happening in a country with a constitution. You could also argue for plea bargaining creating a two-tiered system. Wealthy defendants can afford trials and high-powered attorneys. Poor defendants often lack that, and they plead out due to fear and lack of resources, and this all leads to mass incarceration of marginalized communities. You could talk about in the status quo, the incarceration rates and the divisions between how many Black people are incarcerated versus white people, emphasize the racial inequalities that we see today. A good example for this third contention would be O.J. Simpson. O.J. Simpson, if he didn't have the wealth and power and status that he did had when he went through trial, he would not have gotten the sentence that he did. If a person with the same exact crime and convictions were to go through trial without O.J. Simpson's fame, power, and money, then they would have gotten a much harsher sentence. So you could use that as a direct example to illustrate the two-tiered system and argue that plea bargaining is unjust. And all of these contentions directly fit into the MSV framework. So if that's what you want to consider running, then I would definitely tie this back into your framework, which I think would be pretty easy to do. Overall tips for this topic. For the AF, you should emphasize practical benefits rather than the moral or ethical implications. The moral or ethical implications being helping marginalized communities. Without plea bargaining, the justice system would become overwhelmed. This results in delayed or denied justice, like the court clock case. Functional justice system is better for the majority of the people, which again ties back to utilitarianism, which wants the best for the majority of the people. You could also say that because without plea bargaining, we're going to have clogged courts, which results in delayed or denied justice, and that directly goes against the value of justice that we are trying to reach. And for neg, you should do the exact opposite of what AF is doing and focus on the moral implications, constitutional rights, and real world inequities. Plea bargaining forces potential innocent convicts to take a punishment in order to make things better for everyone, and that exacerbates structural violence. That would directly clash against the utilitarianism framework and support your case under structural violence if that's what you end up running. You want to emphasize that what's best for the majority is not always what is good and what is moral. You want to directly emphasize constitutional rights, that people's rights are being taken away through this process of plea bargaining. You want to emphasize the impact plea bargaining has on marginalized communities. And AF, you want to do the opposite of that. Talk about the majority. What is best for the majority is the best for everyone. We should have plea bargaining, or else we're not going to have justice. Our court system isn't going to work. So those are the main big ideas that I would argue for this case. This case, I think, is a really good topic. The neg and af side both have contentions that directly goes against each other, especially framework debate. That's going to be a big debate for this particular topic because AF and NEG are most likely not going to see eye to eye on framework. So when you are competing, make sure you emphasize framework, always talk about it, always tie back to your framework, always link your impacts to your framework, explain why your impacts are worse or better than your opponents, and talk about, the main points that I stressed for AF and NEG. So thank you for watching. Join us for the next topic lecture and check out all the amazing other outreach resources that we have.